Hello and welcome to the first session of today's McKnight's Workforce Development Forum. You've tuned into what LTC operators need to know about worker misclassification lawsuits. We'll be discussing the ways staff contracted through 1099 models has become increasingly complicated for nursing home providers, especially when viewed through the regulatory lens. I'm McKnight's Senior Editor, Kim Marcellus, and I'll be moderating this event. I'll introduce our speakers in just a moment, but first we have some light housekeeping to take care of. If you have any audio problems during today's presentation, please first check the volume control on your device. This is the most common cause of audio problems. You can also use the help button if your own troubleshooting efforts don't work. We'll have time for a Q&A session near the end of this presentation today. So if you have any questions, please feel free to submit them starting right now in the box on the left side of your screen. And while we don't have any slides today, I'll remind you at the end of our conversation how you can rewatch this session or share it with others after the live event is over. Now, regarding continuing education. This educational offering has been reviewed by the National Continuing Education Review Service of the National Association of Long-Term Care Administrator Boards. It has been approved for 1 clock hour. However, you need to stay tuned for the entire event during its original broadcast to receive a certificate. You can track CE requirements through the course completion tracker, which is accessed through the last icon in the area below the open webinar panel. Once you've achieved 50 viewing minutes, a View Certificate button will display, and the required viewing duration will have a green checkbox. You can then view or save your certificate. A copy will also be emailed to you afterward. And now let's meet today's presenters. Mike Burdick is Chief Legal Officer for IntelyCare. Mike is responsible for IntelyCare's legal, data privacy, and compliance functions and serves as the company's secretary. He has more than 15 years experience in the technology sector, and prior to joining IntelyCare, he served as general counsel at Salsify, a product data platform for retailers. Larry Hoyos is director of credentialing for IntelyCare. Larry has been involved in medical staff, quality management, credentialing, provider enrollment, and revenue cycle industries since 1998. He has supported medical groups, hospital systems, and staffing groups. Larry is a certified provider credentialing specialist and holds a provider enrollment specialist certificate focused on Medicare enrollments. Larry's been with us before, and I'll tell you he's a great speaker. Sean Carney is Vice President of Partnerships for IntelyCare. Sean joined IntelyCare just last December. Previously, he was president and owner of 2 skilled nursing facilities. Prior to that, he was president of CMC Healthcare Management, which operates multiple centers, and also he was with Brookdale Senior Living. He's been a certified skilled nursing administrator since 2004. Hi, gentlemen, and welcome to all of you.
Thank you.
So I'm going to hog the camera for just another minute here. Let me just start this session by reminding our listeners about where we've been and where we are on this issue. LTC providers are increasingly turning to tech-enabled staffing agencies and platforms as an easy, fast way to fill shifts. But aside from the obstacle of simply trying to find people to fill vacancies, there are new financial and legal challenges to consider as policymakers turn their attention to worker classification, both in healthcare and beyond. So temporary nursing staff have historically been classified as W-2 employees, and as many of the newer platforms are offering temp workers as 1099 independent contractors, I think the estimate now is about 25% of nurses and nurse aides are placed in post-acute facility as 1099s now. So a big growth there. With the proposed rule change to the Fair Labor Standards Act and increased enforcement efforts from the Department of Labor, it's becoming critical for long-term care providers to understand how nurses and aides deployed by these platform companies are classified. So let's get into some of the issues. Mike, we're going to start with you for the attorney's viewpoint. Always a good starting point. Can you give us a brief overview of worker misclassification and what it means specific to the healthcare space?
Sure. Thank you, Kim. I want to start off by acknowledging that certainly from a federal perspective, both the current and the proposed rules under the Fair Labor Standards Act are, intended to apply to a host of industries, that rely on independent contractors. So they naturally provide, a certain degree of flexibility for those organizations when assessing classification. We know obviously that's become a hot button issue, which is relevant, in the evolving gig economy. So I think it's important, when we start to dive into the application of these rules as they relate to healthcare and more specifically, the post-acute space, it's important that we recognize that, this is a very complicated issue, where facts and circumstances, and the context are really important. So with that said, I think it's important that we provide a little bit of context on the evolution of the temporary nursing staff space. And so from a historical perspective, with very limited exceptions, and we'll speak to that in a bit, nursing staff were always classified as employees. And over the past recent years, you've seen technology-enabled platform companies emerged in response to, obviously the unprecedented labor shortages coupled by, the increase in demand, which has, in many ways, changed the industry for the better. However, what we also saw during this period is that some of these companies that were opportunistic, particularly during the pandemic, elected to classify their nursing staff as 1099 independent contractors, which is a choice which we'll, dive into deeper as well in a minute, but primarily driven by, a speed to market and lower costs as a result of not having to employ that nursing staff. So I think with that as background, when it comes to healthcare and in particular the post-acute vertical, it's really challenging. And I think arguably, sometimes it can be viewed as somewhat impossible to support that conclusion that independent contractor classification for temporary nursing staff in this space is appropriate. I think for starters, healthcare is a highly regulated field that inherently requires greater oversight and control, that's not required in much of the other gig economy, right? So simply put, I think, we're not talking about the Uber and Lyft models here. I think, as an aside, that has been and still is a highly contested topic for another webinar. But in our space, these workers are interacting directly with, our most vulnerable population. Their purpose is to, ensure that their well-being and health is protected. It's certainly a different standard of regulation involved here in the space, and that's particularly true in the post-acute environment. I think it's also important as we discuss this topic to be clear that the classification, whether it's in employment or independent contractor status, it's not a choice that the individual makes by simply selecting, one tech-enabled platform versus another. As we mentioned at sort of the onset, it's a highly facts and circumstances determination based on the function that they're performing and the manner in which they're performing. I pointed out because we've all seen the arguments that that have attempted to justify the use of independent contractors in post-acute by generally referencing how it should be acceptable because we've seen advanced practice nurses or locus tenens physicians operating as independent contractors in the healthcare space for decades. So the connection should make sense. I think there certainly is a strong argument that these types of practice areas support independent contractor classification. Given how as an advanced practice nurse or a locum tenens physician, you are actually working independently based on a highly specialized skill set, autonomy in your environments, and many other factors. I think for the purposes of this conversation, to be clear, we're not dealing with advanced practice nurses or locum tenens physicians in post-acute spaces. I think level setting a little bit about what that hierarchy in this space looks like is important to giving that context around this conversation. I think for the super majority of the workforce, and that's 60 to 70%, is comprised of certified nurse aides in post-acute, with the remaining, approximately 1/3 represented by LPNs and RNs. In the agencies and the tech platforms that support that workforce from a temporary staffing perspective, they mirror that hierarchy. So I think with that context, the degree of oversight, the training, the control, that's necessary to support, the mission critical workers, in the post-acute environment, and frankly, what the facilities expect, to ensure optimal patient outcomes, it's quite significant, which I think leads to that conclusion around, how it's inappropriate for, some of the staffing platforms you're seeing in the space right today, classifying them as independent contractors.
And I just want to kind of take a step backwards. The reason that that oversight matters is because as a test, whether you're talking about a lawsuit or regulatory level, the amount of instruction that the worker has helps dictate whether they're legally viewed as a worker or a contractor, correct?
Absolutely. It's certainly part of it.
Okay, I just wanted to underscore that. Again, evolving topic, and not everyone is super familiar. So thank you. So,
Yep.
what does increased enforcement of the Labor Department's worker classification of those regulations? What does that mean to long-term care providers?
Yeah, I mean, I think the risks of worker misclassifications are numerous. I like to look at it sort of from two perspectives. I think it's important to not only look at it from the facility perspective, but also the nurses as well. So I think addressing those in parallel is important. Again, kind of providing that context around the conversation that we're having. I think from the nurses' perspective, the nurse and nurse aides, who are misclassified in this environment, by those staffing platforms, are, they're denied employment related benefits that you're typically associated with an employer employee relationship, and those include things like overtime, job protected leave, sick time, health insurance, unemployment insurance, workers compensation, among other benefits. And I think it's also important to note that they often run increased risk when it comes to being underinsured from a professional liability and malpractice standpoint too, when they're operating in these facilities. I think from the facility perspective, those facilities that are engaging with independent contractors, they face, potential substandard patient care and malpractice claims, connected with these staffing platforms. As we talked about at the onset, the very nature of the independent contractor relationship inherently has less oversight over those workers from both a professional and clinical perspective, which leads to everything that you expect it to, in terms of less training, less continuing education, less support, things of that nature. I think it's also important to point out that there's an increased co-employment risk, when it comes to overtime and those job protected benefit and leave, measures we talked to a moment ago, from the facility perspective. And I think it's important to appreciate that, the fact that you're engaging with a W-2 provider doesn't necessarily provide a safe harbor from co-employment risks, but I think in fairness, this is a question of how do you set yourself up for success in terms of de-risking that, and engaging with a W-2 provider who inherently is absorbing all of those obligations as an employer, certainly de-risk that from a facility perspective. And then I think lastly, from the facility perspective, it's important to point out that there's potential from a tax and claim exposure from the IRS, as well, in terms of those unpaid payroll taxes associated with that misclassification.
Okay. And obviously that you mentioned that on the facility side, but that can actually hurt some of the nurses too, that may not know what they're going to come do at tax time, if they've been misclassified.
100%, yes.
Let's dig into the proposed rule, which I'm not that familiar with, so I'm interested to learn more here. What efforts has the Labor Department taken to address worker misclassification, and what can we expect to see in a final rule that's expected this year?
Yeah, it's a great question, and it's interesting because it's certainly not a new issue, right? I think folks get swept up in the current conversation, but it's important to recognize that the Department of Labor has been focused on this issue since sort of the late 1940s, where the adoption of that economic reality test, which was predicated off a balanced sort of 6-factor approach, was put in force, and that was fundamentally the standard that the Department of Labor applied, up until late 2021. Towards the end of the Trump administration, where the DOL issued a new rule to address independent contractor classification. And what they basically did was, they put more emphasis on 2 of those 6 factors. Those being the factors of control and opportunity for loss and profit. And I think with respect to what we've seen regarding the kind of the pending revised FLSA rule, in the coming quarters, I think we're expecting to sort of see that come through, and it's really a restoration of that multi-factor totality of the circumstances approach, and returning to sort of that more balanced, holistic guidepost of those 6 factors that kind of guide an organization's determination of classification. I think we certainly support the proposed rule because it definitely provides greater clarity and guidance around classification. But with that said, when we contextualize this around the post-acute environment, we still believe that under the current rule, as it relates to post-acute vertical, the classification of nurses and nurse aides as independent contractor is in violation of that FLSA standard. And you're seeing that supported even by the current enforcement activity in the marketplace today.
Mike, can you, off the top of your head, go over those 6 categories that you mentioned as being the standard for so long?
Sure. As I said, there's control, which we talked about, which was sort of the current one that's in place. There's opportunity for profit and loss. That's the other one. The other 4 are investments made by the worker. And that really speaks to, how much, investment is that worker making in terms of the provision of the services that they're deploying. Are they, purchasing their own equipment? Are they providing their own, their gear, et cetera? Degree of permanence of the work relationship is another one of the factors. Extent to which the work performed is an integral part of the employer's business is another factor. And this is really interesting because this gets back to, kind of drawing that distinction between staffing agencies being in the sole business of providing staffing, which is different than, say, for example, a company like Google, which isn't in the business of hiring independent contractors to code. They do something else, right? And then I think the last factor is related to skill and initiative. So this gets back to sort of what we were talking about at the onset around, when you look at, the skill set that provides service in the post-acute space versus, the skill set that's associated with kind of your highly credentialed, highly specialized advanced practice nurse or locus tenens physicians. You can see the difference there. So that's sort of a high level summary of the 6 factors.
Okay, great. Appreciate that.
Sure.
So let's talk about some of the things that we're seeing in terms of, I think you guys have referred to it a crackdown, but I'll say just increased enforcement around worker classification. Can you share some examples and activity that's been happening?
Sure. Yeah, and I agree with you. I don't necessarily see it as a crackdown. I think it's certainly more of a heightened awareness around this enforcement, which has been relatively standard, which is a great thing. From a federal perspective, for context, I think we've seen the stats that the DOL from their own website has conducted over 1,200 investigations that we know of. In the post-acute settings, since January of 2021, resulting in, finding violations in roughly 90% of the cases, resulting in the recovery of, millions of dollars in back wages and damages for, thousands of workers. We saw in January of this year alone that the DOL has announced 9 settlements against healthcare sites and/or staffing agencies related to overtime violations. And as I mentioned, this is only what.
Oh, did we lose Mike? All right, let's see if we can get Mike refreshed. I'll maybe just jump ahead for a minute. Larry, put you on the spot while we get Mike back.
Of course.
I see Mike. Okay, he's in and out. All right, let's jump, Larry. So you're again coming at it more from a compliance and audit side versus legal. So we've been talking about the risks that 1099 nurses pose during a DOL audit, or we will talk about that some more. Talk about the audit process that happens. You've been an auditor. What are you typically looking for, and what does that process look like if you come to check for compliance and correct classification?
Yeah, of course. So, I'm usually, as an auditor, going to be tasked with the responsibility to either approve or to kind of just review compliance with the different regulatory bodies that are asking me to go out there, whether it be a Department of Public Health, Department of Labor, or even, a professional board. We really go out there and spend a lot of time at the facility, at the organization, at the site, in order to kind of really get down to looking at policies, procedures, looking at organizational setup, organizational structure, and just a lot in terms of the site's responsibility with that employee. And that's where the 1099 kind of question comes into play, is because we do look at contracts. And if there's an independent contractor contract available, what that relationship is, what the scope is, and look at the identity between employee and independent contractor within that facility, because they can be used in different ways. And I believe it's just the way that whenever there's a complaint, whenever there's a question, whenever there's an alert out there, nowadays where audits are a little bit more prevalent just because of systems going back into play, it's now time to go out there, and the organizations are becoming more active and being able to get down with the organizations to go through the audits. We do look at a lot of the information in terms of training, in terms of just onboarding process, in terms of talking to leadership, talking to even employees on how they were onboarded, what type of competencies they can verify, and also just the structure around how they're managed as employees or as partners in that organization. If it's a contractor, a lot of the owner is left on them to provide, whether it be documentation, whether it be scope of practice, whether it be just a relationship in terms of how they're interacting with those services that are being held.
So this isn't on my list of questions, but I'm curious, Larry, are these audits required at a certain space or interval, or can they be triggered by complaints or concerns?
Good question. And a lot of times it's both. In terms of any type of licensing, any type of compliance, it's usually done on an annual basis. And those are pretty standard. People are told, people are scheduled. We go out there and we let them know months ahead of time to prepare, and then the items that we're looking for, which is a general personnel file, etc. The other times where audits can happen is that when there's an alert made to a regulatory body, whether it be a complaint, whether it be some sort of discrepancy, and there we would go out with a little bit more focused review period. Okay. And then once that happens and it's completed, then we go back out again in regular intervals until we're satisfied that those alerts have been completed, satisfied, followed up on, etc. The idea of that, and that was, like I said, it was a good question, was because if there is a complaint, if there is an alert, if there is a discrepancy found, in an auditor's perspective, and we'll go over a little bit more of the details on documentation, but in an auditor's perspective, when a red light, if you will, has been announced, then we know that maybe we're going to have that same type of discrepancy in another facility within that organization. So it really gives us that almost that keen eye, and then we begin to put more focused blinders on looking at those to find out if it's a organizational wide or if it was just happening at that one particular moment in time.
Okay, so absolutely need to be prepared. I'm going to stick with this topic for 1 second, and then Mike, I promise we'll come back and we'll get to that answer that you were in the middle of. So I want to ask Sean's perspective here. He's just recently transitioned from being in nursing homes all the time, dealing with all kinds of audits, but in particular, what Larry described sounds a little stressful. Can you talk about your audit experiences, Sean?
Sure, absolutely. I was taking some notes down in case we had to come back and revisit this after Mike got back on. But from an operator's point of view, the audit process within itself is extremely stressful. And I immediately go to how that stress is felt and absorbed by the facility and who that affects directly. And of course, that's the residents. So while the auditors, whether they're there for the Department of Labor or the Department of Health or any other governing or organization, their intent is not to cause any disruption to the facility. But we all can understand that the very nature of them being in the facility and the heightened awareness that it brings to all of the staff members that are working that day is felt throughout the building. And again, most importantly, it's felt by the residents. So as soon as a audit of any nature begins, one of the primary focuses is managing that stress. And from that point forward, it's the facility's job to be able to provide the information that the auditor is asking for. There becomes a time component to that ask. And in this digital age that I believe Mike was starting to hit on earlier, that time frame has shrunk as we move towards a more digital world. And I say that tongue in cheek in the long-term care space, because the long-term care space historically is anywhere between 5 to 10 years behind the rest of the world in technology. So if you can imagine, as Larry pointed out earlier, he is looking at a lot of information. He is tasked with identifying and sourcing a good deal of information. And for the on-site nursing home to provide that information in a timely manner sometimes means going down to basements and rifling through file cabinets to identify 1 or 2 pieces of information. And that task falls on usually a group of office staff or administrative staff. And if we are truly thinking about the operational structure of a long-term care facility, there are not many folks at that level. So oftentimes that means the administrator or myself, the owner, or the president of a management company, physically coming in and on the hands and knees in a basement, rifling through files, trying to find this documentation. And then to further Larry's point, if and when you are not able to find a piece of documentation, you start to show a break in operational structure and performance. And once the auditor has put those blinders on, as Larry so eloquently said, and starts to focus in on that topic, it shows a lack of principle and focus for that particular facility within the area that they're auditing. And once that happens, your audit has now accelerated from, if it's a general audit or an annual audit, to a more focused audit. And that in itself creates more pressure. And as that pressure builds, the employees feel it.
So one follow-up for you, though, I think we've talked about this in previous webinars. You talked about being 5 to 10 years behind on technology. And so the explosion of apps and platforms that allow you to easily get staff sounds like a great solution. Like, let me pull out my cell phone, hire somebody in 10 minutes. But can you talk about maybe some differences you've seen without naming names, but just the idea that not all apps are created equal, that you want to know, are they compiling the information that my auditors are going to look for? Can my agency or my staffing partner get that for me quickly if I don't have a paper copy in the basement?
Absolutely. That's an excellent point. And I can actually go right back to my personal experience when I was an owner operator through the pandemic, and I had not previously used auxiliary staffing in my buildings, but during the pandemic, things changed and I had to begin a process where I vetted out companies to provide that staffing for me. And one of the things I looked for was, we are ultimately, as an operator, you are ultimately responsible for those staff members that are caring for the most vulnerable population within the building. You hold that responsibility. So one of the key factors with a W-2 employer, especially IntelyCare, is on that app, you are able to see a full human resource style profile that has the credentialing done by Larry's team and or the licensing And we have access to that, which is extremely helpful in an audit, as opposed to being in a situation where you are trying to track down that information and there isn't really a source to gather that information. Because if they are operating in the 1099 model, this is not something that's happening on the back end. And that search for information, much like what we previously spoke about, becomes an issue within the audit process. I hope that answers your question.
It does. Thank you. So let's go back to Mike and I don't want to scare people, but let's make the case for why both doing this the right way and documenting it correctly is so important. Mike, I think you you were talking about 9 cases in January of this year alone at DOL.
Yeah, thanks. Sorry about that. Just recounting some of the recent activity that we've seen from the enforcement perspective at the federal level, surrounding those, 9 settlements, against, healthcare facilities and staffing agencies as a result of overtime violations. And then, noting that I think it's important to realize that these are just snippets, right? These are what we're able to pull from the publicly available data from press releases and the DOL websites. And so it represents, only a percentage of the enforcement activity that's happening. I think in particular, one of the recent enforcement actions that is important to note is one that's occurring in Pennsylvania around the DOL, taking action against a facility for an alleged, I think it's 19 million or approximately 19 million in unpaid overtime expenses. The basis of the enforcement action, again, predicated on a large number of the facility's workforce coming from a tech-enabled platform provider that classifies its individuals as 1099 independent contractors, and that failure to pay overtime. So you're seeing this happening, at the federal level, but we're also seeing this happening at the state level as well. Whether it's from the perspective of Illinois, Oregon, Louisiana, Pennsylvania, Connecticut, the list goes on around those states either recently enacting or amending laws that are specifically addressing healthcare staffing organizations around their requirements for licensure and compliance, laying the groundwork, that fundamentally provides a system for penalties beyond fines and lawsuits that can jeopardize sort of their ability to kind of do business in those states. So, I think it's an important illustration around that push to protect those nursing professionals, at both the federal and the state level.
Let me ask a question on that Pennsylvania case. You said $19 million in unpaid overtime. Do you recall, is that against the agency or is that against the facilities or both?
My understanding is that the enforcement is against the facility, but it's wrapping in potentially both.
Okay. So my question is, as a provider, would I know potentially if I had employees, yes, I know that they're working in my building more than 40 hours a week. Do I know necessarily if they're getting paid overtime?
Yeah, it's a great question. I think this gets a little bit to what Sean was alluding to in terms of that visibility, and leads into a lot around this education in the space, which just historically has not been sort of top of mind. I think what we're also trying to drive here is the visibility into understanding the downside implications of not knowing the type of staff that you're bringing into your facilities, because it has all of these downstream implications that we've spoken to, right? And so I think many times, as I think you even alluded to, from the supply side on the nurses end, they're oftentimes not even aware when they're choosing one app provider or another, whether that's leading them down a pathway towards employment or independent contractor status. And I think it's fair to say that that conversation around the education from the facility side is somewhat similar.
I think there's a concern too. I mean, in that Pennsylvania case, it looked like some of the workers may have been working 70 hours a week. And so if you're repeating that violation, again, really doesn't matter for this lesson whether it's the facility or the agency making the mistake. But if somebody's working 70 hours and not seeing overtime, are they going to want to keep doing that job? it's just another factor, I
Right.
think, that chases people out. So it doesn't help anyone in the long run.
Right, exactly. And I think it's one of those things that extends towards the very nature of, the FLSA standards as they apply kind of agnostically to protecting worker rights, but specifically given the backdrop and the context that we spent a lot of time talking about on this chat related to those critical providers in the post-acute space who are not only operating under a very highly regulated environment, but it's incredibly stressful as well, right? The inherent nature of the job they're performing. And so to your point, those protections are put in place for a particular purpose.
And I want to give you a chance. You mentioned Illinois. Can you talk a little bit more about states and their efforts to put rules in place around classification?
Sure. Yeah. I think, with respect to Illinois, and it's just, again, one of the examples, as we're seeing this happen in a handful of other jurisdictions as well. In the summer of last year, 2022, they amended their Nurse Agency Licensing Act, and it's fundamentally the regs that govern the provision of temporary nurses and nurse aides to healthcare facilities. And they did that to not only enhance the reporting requirements and improve transparency, to better protect the nurses and the nurse aides in the facilities, but also clarified the scope of the act. And I think this is where it's kind of important to kind of understand what's driving some of that, right? So, you're seeing in the space, many of the, technology-enabled platforms that classify their workers as independent contractors, have either historically failed to, or in many cases still haven't obtained proper licenses to do businesses in these states, including Illinois. And I think it's premised on a somewhat interesting argument that from the 1099 perspective, these entities are platforms, and all they're simply doing is providing a marketplace, that does little more than serve as a conduit, if you will, for connecting the supply with the demand. And, therefore they're not, subject to these types of regulations and don't need to comply. Well, I think the reality of that is that it's clever, but fails certainly for a number of reasons. I think first and foremost, on the face of some of these statutes, taking Illinois, for example, you're seeing that these states are becoming very particular in the scope of how they define nurse agencies to cover, any facilities that, not only employ, but also, somehow manage to appoint or supply, any type of nursing staff to facilities to cover the end arounds for making that kind of platform-based argument. As well as including language, and I know this is in the Illinois one, around being very clear that the individuals that perform the services under these statutes will be deemed employees for purposes of these statutes. And then I think it gets back to sort of just the other instances that we were sort of talking about at the onset, around just the inherent nature of the temporary staffing in the post-acute space. And that heightened degree of control and oversight, which just simply doesn't support that independent contractor, argument in that sort of free marketplace where you're just simply connecting supply with demand.
Okay, great. Thank you. So now we're going to jump back to the audit side of the conversation. Larry, we started to get into this, but let's go a little more detail in terms of the tangible process of an audit. What level of documentation is needed, and how does the process typically go?
Yeah, definitely. So the process, as an auditor, I've done audits in several different types of facilities, whether it be rural, large, small systems, and where you can really get in there. And what we really do is go out there and we notify the organization if we're allowed to, and we have them with an agenda, getting items laid out. We want to be able to interview employees. We want to be able to interview administration. We want to be able to look at the facilities to make sure that they are meeting all of the requirements depending on what regulatory body is out there. There are some documentation pieces that we really focus on, and a lot of it surrounds compliance or surrounds HIPAA, OSHA, CMS, making sure that those facilities are compliant, making and doing those trainings, having those informational sheets signed, et cetera, by the employee. You know, we look at employee personnel files, making sure that if they are hiring employees or W-2 workers for the sake of this conversation, to ensure all of those items have been done, whether it be the background checks, et cetera. On the opposite end, if they are contractors, we're going to be wanting to look at the actual independent contractor agreement, which will outline the scope of the relationship between the contractor and the role that they're being contracted to perform. Same thing with any BAAs or business associates agreements, to make sure that those other HIPAA items are complied with the contractor, because they would not fall under the W-2 relationship. You know, and then we look at basically processes and procedures on how staff is managed and how processes are managed and how situations are managed in any type of event, or, you know, God forbid a sentinel event happens. Where does that relationship lie between an independent contractor and a W-2 employee? A lot of times the liability falls on the facility to be responsible for a lot of that information, which is why we want to make sure all that documentation is outlined, it's in place, I's are dotted, T's are crossed, if you will, to make sure that things are going to go okay. You know, in terms of the W-2 versus 1099 relationship in a facility, it goes back to like what Mike mentioned about the management of the employee. You know, there's a scope involved on an employee where we have, or the facility has, a lot more responsibility to provide support, to offer guidance, to train, to oversee, et cetera, for that employee. The independent contractor, not necessarily. A lot of times it needs to be called out in the contract in terms of hours worked, in terms of where they're going to be working, what type of services they're going to be providing. So we really need to look at a lot of that information in order to ensure that we are getting, or we're having fulfilled the reason that why an auditor is going out to that organization. You know, in terms of liability insurance, I think is probably the one of the larger, more elephants in the room, is that who's liable when an independent contractor has a discrepancy. They can't find any information. Well, it generally, having that contractor piece, it's also the facility's responsibility to have the documentation, but being able to manage that comes into question, because it's on the responsibility of the independent contractor to provide the information. Sean talked about having almost like a credentialing passport, or almost like a credentialing profile within an app electronically, because these facilities too are handling in paper. You know, I still review paper files when I go to a location and sit down with the box of files being carted down a hallway and sitting in a conference room. That still happens, and it's out there. It's something to realize. But having it electronically does make things easier, because now we live in our more technology-driven space. Turnaround times are a lot shorter. Requests are a lot shorter. We don't have a lot of time to do snail mail. We don't have a lot of time to get that audit done, just because of the volume of items that are out there nowadays.
So something else that I had in my notes was talking about if you have to find the contractor, does that mean the employee, if you have to track down that 1099 employee for questions? I mean, that just sounds incredibly challenging, knowing that they might work in multiple buildings.
It can be, especially if they're per diem staff, or, not working every single day or in a specific location. It can be, which is hopefully the reason why in any type of audit, we would allow the facility to manage that gathering of employees, if you will, just to make sure that somebody is available that can answer questions, provide documentation. Otherwise, if there's a specific case or a specific question we need answered, then it is a lot of manual work, if you will, to hunt down that person or hunt down that individual to get that documentation, get the interview completed, to make sure all the documentation for the audit is completed. It does present challenges a lot on both sides. And that leads to what Sean was mentioning earlier about the stress level. Stress level in the facility. I walk in, I'm not so much of a bad person personally, but people already have that idea of, oh God, the state's here. Oh God, the federal government is here. or they're auditing, we're there to just ensure compliance. We're there to ensure our patient safety. We're there to ensure quality is being managed appropriately. And most of the time, we're there to just provide guidance and making sure that, hey, this is not quite the way it should be. Let me give you an opportunity to fix it, and we'll come back, in a month or in 6 months to review to make sure things are going okay. It does present, like I said, we've done joint commission audits, which happen every 2 years. Everyone understands that they happen every 2 years, usually on a calendar time frame, but months up to, the stress level just increases at facilities or at organizations. Same thing when it's a surprise audit. Many facilities that I've been to on a surprise, you just see people just stressed out. And Sean does make a great point. It trickles down all the way down to the patients because they feel that, whether it be delays in care, whether it be just people running around, or it be, me going into a facility and interviewing a patient, if you will. So it does cause that type of environment or atmosphere.
And Sean, I did want to come back to you. And I know we sort of already asked this question about the stress level, but I think one of the things you had talked about were the intangible costs, and this idea that as the owner or the admin of a building, you might be pulled away to deal with this. Can you talk about what that takes you away from? But again, if you just want to reiterate on the costs and the time spent.
Sure, that's a great point. I actually had written down in my notes. I wanted to go back and highlight some of the things that Mike had brought up earlier, and it ties in perfectly with the question you said. You just asked. The visibility and the responsibility for the employees or the vendors that are working within a given community's space is the responsibility of that community. And I want to highlight the limited resources that long-term care is working under at the upper management level. So it's why it is so vitally important to have transparency and provide education for any kind of vendor or tech-enabled platform to be a true partner with the community or the facility that they're working with. And then to your point, because of these limited resources, especially in the smaller ownership groups, whether they be single ownership or maybe 10 facilities or less, it requires the management company and or the owner, which is usually the same person, to then get involved. And when they're involved, there is a cost to that. There is, you are taken away from your day-to-day tasks, such as helping to negotiate better employee benefits, or helping to negotiate or work on contracts with other vendors to receive goods and supplies that hit the bottom line on a day-to-day cost per resident, which in the long-term care industry, that margin is paper thin. And when you have a cost that is raises at a level that you are unable to account for quick enough, the offset has to come somewhere else. And when the offset comes somewhere else, another person in that facility is affected. And it puts a tremendous amount of pressure on the owners and the operators of these facilities to assure that patient care is not affected by that change or loss or increase in costs. So that's a balance that you have to play with on a day-to-day basis. And you want to always be prepared and be able to demonstrate your ability to comply with any audit. And if you are being taken away from your day-to-day tasks and you're diving headfirst into an audit, you are inherently being pulled away from another duty that you have. And there's a cost associated with that. And with margins that are paper thin, if not running in the negatives in most cases, there are issues that follow from there.
All right, we're getting towards the end here, and I want to leave some time for Q&A. But Larry, I wanted to come back. You talked about your presence in the building, but I wanted to give you the chance to talk a little bit more about why you think a W-2 employer being a W-2 employer can relieve some of the stress around the audit process?
Well, it comes back to the idea of being able to manage all the information, being ready for any type of incident where an auditor needs to show up at a facility. Having a W-2 employee, the full responsibility is on the organization to have and itemize all that documentation for an auditor or to meet compliance in any way, shape, or fashion. Whereas being a contractor, the responsibility to gather the information is on the facility, but the responsibility to manage it is really on the contractor. So it's a lot harder, like we mentioned earlier, it's a lot harder to hunt down the information if it's a specific piece of information we need, whether it be training. Best case scenario would be a facility would perform or provide all the training that independent contractor needs to have. However, it's not a requirement. So, from a cost perspective, it's usually better to have the independent contractor provide the training if they've taken it other places, since most of the time they would have worked somewhere else. But the responsibility then lies on the facility to ensure that training, that piece of documentation, the compliance training was sufficient to meet their standards, because that's what we're going to be going and looking for based on the facility. Like Sean mentioned, the facility is ultimately responsible because that's where the agreements come into play to make sure that the agreement with the contractor matches all the requirements on the facility. And there is a lot of times where the contractor and the facility come to the agreement in a way, shape, or fashion that the facility relies on that agreement to ensure that the contractor is compliant. And if not, then that's where the deficiencies come to play. But having a W-2 employee in that role makes it a lot easier, because the facility can speak to those arguments, can speak to the questions, can speak to the process and the quality of the process, more comfortably.
Okay, great, Larry. So Sean, forgive me, I'm going to jump to the Q&A, so I don't want to run out of time. And we do have a couple of good questions here, so maybe you can weigh in on some of these. I just wanted to go back to the basic question about who decides whether the person who's coming into your building is 1099 or W-2. Is that the staffing agency that they're working for, or is that the individual worker?
I'll take this one real quick. I think that we're not saying that there's a right way or a wrong way to do it either way, but the staffing agency or the vendor is making a decision at the front end of their business model as to how they choose to employ their care professionals. At IntelyCare, we call them IPs. So the business itself is making that front end decision. As far as who walks through the door in the facility, that responsibility falls on the operator to fully understand the companies that are approaching him or her and which services they choose to engage with. So it's kind of a two-ended question, two-parted answer to that question.
I'm going to throw a third part on there, because we had someone who would like to know if you have an employee who's a 1099 and you'd prefer them to be a W-2. Can you have that conversation, and what would it take for that to happen? They'd have to move staffing agencies or come to work for you directly, right? They
would. I would have to think with all of the recent happenings and the legislation that's coming down the pike, all vendors are probably taking a look at the way that they do business and they operate. And I'm proud to say that IntelyCare made that choice at its inception to become a W-2 employer. And sure, we certainly have care professionals who have made that conscious choice due to some of the risk factors that I believe Mike spoke about. It's a two-sided risk factor, both for the facility and for the care professional when working 1099, and fully understanding what some of those ramifications could be. When the nurses that I'm speaking with at varied conferences and when I'm on the road start to have a stronger understanding of what the differences are, we are seeing a migration towards the W-2 employer for all of the reasons that Mike brought up. The built-in employee protections and benefits are key to enhancing a workforce that is already operating in a burnt out, highly stressed field post-COVID.
All right, let me switch this topic a little bit. Mike or Larry, you guys tell me who's best to answer, but specific to care quality, can agencies that deploy 1099 contractors provide any kind of onboarding or other training for aides, or does that make them an employer?
Larry, I can take this one,
Okay.
and then certainly share some color. I think that gets at the heart of what we were speaking to, right? I think there are various things that are tied to, those classification tests that make it very difficult, if not impossible, to provide the level of training, from the onset, initial onboard, but as well as that continuing training and support, whether it comes in the form of education, from a clinical perspective or otherwise, from a 1099 platform. It just is inherently in conflict with that whole notion of control of the worker. So from my perspective, particularly given the nature of the post-acute environment, where the staff that supports that system has an inherent, heightened degree of, oversight in terms of the functions that they're performing, it makes it very challenging.
Larry, do you want to add anything?
Just that's the 100% agreed. It does make it challenging. A contractor would not have the full access that a W-2 employee would have in terms of an organization. They're more of a contractor. They can contract out services depending on the agreement. So it does make it difficult, which is why we have that option, or the contractor would have an option to provide outside training, but we always would want to make sure that it is compliant, it lives up to the standards of the organization. Okay.
I have 60 seconds for the next question. This will be the last one. But again, whoever wants to jump on here. Are there any industry associations or advocacy groups working toward a resolution to the worker misclassification issue in healthcare?
I'll take a quick stab at this. As an owner-operator and an administrator in my past life, I was part of numerous organizations such as ACHCA, the American Healthcare College, AHCA, and other varying groups, trade associations within the states and national trade associations such as Leading Age. And I have been to the previous 3 or 4 weeks, I've attended the national conferences of those organizations. And this topic is front of mind with everybody, having both educational seminars and topics outside of the individual educational seminars throughout these convocations or these conventions. So my answer would be yes, this is top of mind across the country, both within the corporate and the privately owned long-term care facilities.
Okay, quick question, Mike. On the DOL proposed rule, do we know when that could be finalized?
It's tough to say. I think we expect it to sort of hopefully clear in the next, coming months. But as you can appreciate, anything having to do with getting through, the rulemaking process is sometimes less than a clear process, right? So we're okay. Certainly keeping our eye on it. And I expect the industry will as well.
Okay, great. All right, everybody stay tuned for that and much more, obviously, on this issue. So with that, I would like to thank all 3 of our speakers from IntelyCare for sharing their experiences and a variety of perspectives on this issue. You can learn more about IntelyCare, which sponsored this session, at IntelyCare.com. And be sure to come back for our next session in today's forum, which begins at 12 Eastern. That's creating an employee experience for your modern day care force. And remember that you can watch this session again or catch any of the others from today's Workforce Development Forum shortly after our live event wraps up. That will be at mcknights.com/05-1823 Workforce Development Forum. You can watch replays or register so that others can watch it for the first time. And for McKnights, thank you so much. Have a great afternoon.
Thank you.